Hello and welcome to the Student Undergraduate Research Experience. My name is Merle Massey and I'm the coordinator of undergraduate research here at the University of Saskatchewan, and this is another presentation for our SURE program. This is actually the first in what we have come to talk about as our entrepreneurship modules that are coming to us from Research Excellence and Innovation here at the University of Saskatchewan. There are 9 in total that are coming up, 3 this week, so really busy. But with us today is our kickoff event, Commercializing Ideas at the University. And with us is Chris Bowman, who is the Technology Transfer Manager at Research Excellence and Innovation. And Chris, Dr. Chris Bowman, I will pass this over to you.
Thanks very much. So I'm one of the tech transfer managers. I guess there's 2 of us now. And John and I like to say that he mostly deals with things that are living, and I mostly deal with non-living stuff. So my focus tends to be on technologies that are in engineering, physical sciences, chemistry, computer science, machines, devices, and so on. And there's a lot of overlap in interdisciplinary stuff that we'll sort of tag team on, but generally that's how we kind of break up the workload at the office. So what we do, we've changed names a number of times over the past 5 or 6 years. We used to be the Industry Liaison Office. Then we were Innovation Enterprise for a while. Now we're Research Excellence and Innovation after being merged into a larger group. But the sort of mandate of my smaller group is to look at the ideas that come out of the university that maybe would lead to a product or service that could be built or delivered that the university is not really in the business of doing. The university's core mandate is research and teaching, so we don't build antennas or anything like that, and try to find private sector partners that can get on board and take ideas out of the university to something you can buy in the marketplace. So just a brief outline, I'll talk a little bit about the process for research commercialization at U of S. I'm going to give a very high-level overview of what intellectual property is, the basics of IP, and then how IP works at U of S and how it fits into sort of a commercialization model. So as I said, we work with campus innovators and also a lot of stakeholders outside of campus, entrepreneurs, investors, business experts, large companies who may be interested in bringing on university innovations to try to get ideas out of the university out where they can have impact as a product or service. So most of the great ideas out of the university come out, the standard model is you publish, lots of people read your stuff, they take it, they build further on it, and that's great. And we definitely don't want to get in the way of that. That is the university's core mission. But as I said, every once in a while you get an idea that looks like it could show up as a product, and we want to get partners involved that can take that to the market where it can make a difference. So the screenshot I got down there, the guy on the right there is Steve Foley. He's a faculty member in chemistry. Some of you may know him. So Steve and his 2 at the time graduate students in the middle had developed a process for leaching gold. Gold is a noble metal. It's difficult to oxidize. It's difficult to get in solution. This is one of the reasons it's valuable. So they've come up with a novel chemistry to get gold into solution, which really allows some revolutionary changes in both the mining space, but also the recycling of old electronics. There's a lot of gold in used electronics. So being able to extract the gold from waste electronics makes the recycling stream and process a lot more, there's a lot more incentive to recycle old electronics by being able to extract that value from it. And the background here is they're on Dragon's Den. They pitched to the Dragons a couple of years ago. Got a lot of interest. They had an offer on the table from all of the Dragons, which Steve tells me has never happened before. And then they turned the Dragons down. So they found other external investment and decided to go with them instead. The guy on the left is an entrepreneur who was involved in the early stages of getting the company up and off the ground. So he saw the initial sort of promise to the technology. We had connected them together and let them sort of take it to the level they could, but often with taking technologies to market, especially if you're going through the startup company phase, it sort of happens in levels where a little bit of money comes in at the first stage and you take that as far as you can, you show some promise, and then you take that promise and you look for bigger money to get to the next level of a pilot plant or something like that. And that's exactly what's going on here. They're looking for investment to try to take this to a larger scale. And the company is still up and running, still doing great things, and yeah, continually growing. So it's one of our good success stories. So this is a little bit out of date, but I kept it here anyways. A, because it's a good brag slide, and B, because it's a example of how quickly things change in the world of university research commercialization. Because as of the time of this slide, we were the #1 university in Canada in terms of licensing income. That was largely from one invention, a vaccine for an animal vaccine for pigs and circovirus, which was a huge blockbuster commercial home run for the university. But as I will be telling you later, patents have a limited lifetime and things go off patent. And as this went off patent, our licensing income has fallen off a lot. And so now we've fallen far below #1 nationally in licensing income. And now we're working to get back up there. So there's a number of promising technologies we have that we're hoping can kind of get us back and replace the hole that the vaccine going off patent is leaving us. So we have a number of files, just some stats on the office, but the picture here is from 2 summers ago. So we used to run a program for student entrepreneurs where we would take technologies that we had disclosed out of the university and put student teams together to try to move that technology to market. So this is one of the teams showcasing their technology, which is a biolubricant, to a number of people at an open house type event. We aren't running that program this summer for a variety of reasons, but some of the, I guess, maybe expertise and teaching materials we developed over the course of that program are showing up through the SURE program now. So this is in some sense a little bit of a successor to that, but it's a different incarnation. It looks like there'll be a successor of the summer entrepreneur program running out of engineering. We're hoping next summer. And we will be sharing more information about that as we know more about it. So that's kind of who we are. We're the office at the university that looks at commercializing university research. So I want to sort of switch gears a little bit now and talk about the process of going from sort of a lab-based discovery to, ideally, at the end of the road, something that shows up in a marketplace. So there's a lot that can be done to get from a great idea to a product, to an invention. Let's start with first. There's design, there's implementation, there's a lot of details that need to be worked out between, I have a great idea and actually building that great idea. The example is often used the people often use is, it'd be great to build a time machine, but I have no idea how to build a time machine. So having the initial idea is a great starting point, but it doesn't get you. There's a long way to go beyond the initial conception. Most of that early work gets done in a place like a university, in a lab, where a lot of the maybe this might work. Sort of very early stage research gets done. I'm talking about the gold leaching company from earlier. So they would describe this as beaker chemistry. So you've tried a bunch of stuff in the lab to try to get to your end goal. It'd be great if we could put a solution together that oxidizes gold and gets it into solution. And they work in the lab. They have ideas based on their sort of scientific expertise and background. They throw them together and they get something that's great, and it works great in the test tube. And they can demonstrate reaction kinetics that are orders of magnitude faster than anything else out there, as well as a selective ability to get only precious metals and not everything else into solution, which is exactly what you want. But there's a long way to go between this and a factory processing things at a large scale, and oftentimes inventors don't always appreciate the huge gaps. And it's in some ways it's even worse on the life science side, because regulatory and clinical trials and so on are massive undertakings and require huge investment. So there's a long way to go from a sort of university scale. This is a great discovery to something that can actually show up in a product. And my slide of failures: not all good ideas succeed. So I have everything from the VHS VCR for dipping back in time a fair ways there, which beat out another format of video recording that was in all technical ways superior to it, but for whatever reason the marketplace liked the VHS format. There's the famous Ford Edsel, the Barnes & Noble Nook, which has been crushed by Amazon's Kindle. Well, everybody knows the BlackBerry story in Canada, and there's the Samsung Note 4, which had a tendency to catch on fire. All of these are things that had a lot of engineering, design, and work put into them that just didn't take off in the market. So there's a lot of failures on the way to a success in a marketplace. And this is a slide that sort of is supposed to illustrate that. So at the science stage, the lab stage, there are thousands of good ideas. Looking at sort of scale up to go from the sort of theoretical underpinnings to something that sort of works at a lab scale, well, that winnows out a whole bunch of the ideas that never pan out. And then the question is, can you actually build those things? Now we're talking about engineering and design, and again, a lot of the things that make sense on a small scale or with a simple design don't really pan out as something that can actually be built. And then the business has to make sense. Can you build it for less than you can sell it for? Do people actually want to buy it? And finally, from all the thousands of ideas at the very wide end of the funnel, you might get a new product coming out. So I'm going to pivot again a little bit. So when looking at taking an idea from, let's say, from lab to market, one of the things that's going to come up over and over again is intellectual property. So basically, the broad strokes are: who owns this idea that I had? Can I own it? And how do I enforce the fact that I had this idea that I think is going to be worth something? So there's this notion in law of intellectual property. It's just like property, but it's not physical property. It's not the table. It's not the laptop. It's an idea. It's not all ideas that rise to the level of intellectual property, but it's been decided over years of evolution in the legal system that certain kinds of ideas are things that we would like to be able to protect, just like we protect property. So that just like nobody can take your car and drive it off without your permission. You can do the same thing with some kinds of ideas. So it's something you can own, something you can protect by law. The laws are going to vary by country, and I just want to make sure everybody understands that I am not a lawyer, and even if I was a lawyer, I am not giving you legal advice. If you have any specific questions about IP with anything you're working on, please go talk to a lawyer. If you're at the university, you can come talk to us first, and we will put you in touch with the people you need to, or at least if we can't help you directly, we can point you in the direction of somebody who can help you out. So the property in IP is the right to exclude someone from using your idea. Again, not all ideas rise to the level of intellectual property, but those that do carry with them the right for you to say, this is my idea and you can't use it. And you can buy and sell these rights. So this is my idea, you know, you can't use it until I sell it to you, and it's still my idea, but now you own the right to exclude people from using the idea, potentially even including me, because I sold you my idea, or I rented you my idea, I leased you my idea, which is what we typically do in a university environment, which is through a license that gives anybody who's interested in using the intellectual property we have the right to do certain specified things with it. So it, you know, if you think of the property and IP as fencing off an area in the sort of space of ideas and saying, this is mine, nobody else gets to come in here. You could say, okay, I'm going to let you come in here, you know, for a limited amount of time, and I'm going to let you do certain well-defined, specified things with my idea, and in return, you're going to pay me some kind of rental or royalty or some kind of fee to compensate me for getting the right to move into my fenced-off garden of ideas. So there's lots of IP that really can't be very well protected, and ideas broadly defined is sort of the top of the list. So, you know, I if I throw out an idea during this talk, like it'd be a great idea to have, I don't know, a dog walking robot, and I think, you know, here's an idea how you build it, and you put some sensors on the front and a thing to hang the leash on. Everybody's allowed to take that idea and go run with it. I have no way of stopping you. I'm telling you about it. I'm throwing it out there to the world. It's the world's idea as soon as it sort of leaves my mouth. And that happens a lot in a university environment because our business is publication. So as soon as an idea shows up in a publication, you know, the whole sort of model for academic publication is that other people will take that idea and build on it and will cite you. But the idea is out there. You can't stop people from using it once you tell them about it. You know how, broadly speaking, is something that a term that shows up a lot. You know, if you know how to do something, that's intellectual property, but it's kind of hard to stop anybody else from also knowing how to do it. Training, if you're an undergraduate student here at the University of Saskatchewan, you're here because you want a degree, presumably. That degree is a bunch of intellectual property that is in your, or represents a bunch of intellectual property that's in your head, and it makes you more valuable, right? If you have your degree in whatever, engineering or computer science or English literature or whatever, you are more valuable, and you have a piece of paper or some sort of document that tells people you know a certain amount of stuff about a certain amount of things, and therefore they can trust you to do certain kinds of work that's more valuable than the work you'd be able to do without that. So there's value to that IP. The way it's protected is really because from the degree granting institution level, you know, you need to jump through the hoops that the university makes you jump through. I shouldn't disparage the examination and degree collecting process at the university, but the idea is you have to do enough at the university to demonstrate you have that level of knowledge in your specific field, and then the university, who is part of a limited group of institutions that can give, you know, the checkmark thumbs up saying, you know this stuff, they will grant you this degree, and then that degree is valuable to you. And there's some level of protection on that. So anyway, but the broadly defined protected IP types, there's generally speaking 4 or 5, depending on how people count them, types of protected IP. And I have examples of them on here. I'll go through some of the details. There's trademarks, copyright, trade secrets, patents, and there's also design patents, which are a little bit different. So they can show up a little bit in different ways, but they're often sort of thought of as sort of second class, but they can be really, really valuable. Trademark is probably the simplest. I shouldn't say simplest, but it's really just like a blurb or a tagline or a simple logo or something like that that identifies you. University of Saskatchewan has their seal, Apple. Everybody recognizes the Apple or the Marvel Studios or the MasterCard logo. And it identifies a business as providing a certain, having a certain goodwill. They've built up a goodwill in the marketplace. It's valuable. If you see the Apple symbol on a laptop, you have certain things you come to expect will be in that laptop. Whereas a different mark will convey different information. So these things are protectable. Nobody here can go into business and start slapping Apple logos on the back of their computer, because they will very quickly, as soon as Apple notices them, get sued. Because Apple values its brand and it values the notion of what an Apple product is, so they stop you from working their intellectual property. Trade secrets are things that don't come up very often in a university environment because we are really not very good at keeping secrets, broadly speaking. We can, of course, if we have to, but generally speaking, the goal of a university is to do research and teaching, and both of those are not secret things, right? Research, you tell the world about something. Happens a lot more often in business. It gives someone the exclusive right to use their secret as long as it's a secret. They have to take measures to keep it secret, and it's very vulnerable because if somebody independently discovers your secret, well, it's not a secret anymore, and as long as you can't show that they learned it by breaching the measures you took to keep it secret, you may have no recourse. So trade secrets are things like people will talk about, like the formula for Coke, or the herbs and spices in Kentucky Fried Chicken, or what have you. Things that maybe aren't easy to reverse engineer necessarily, but they often also take the form of things like customer databases. SaskTel's customer database, they will regard that typically as sensitive, secret business information. They don't want that getting out there. They'll take measures to protect it, and it's valuable to them, right? Knowing who their customers are, when they paid them, what kind of phone they have, or what kind of service they have, is valuable to their business, and they will keep it sort of as sensitive business information because they don't want everybody to have that. Yeah, as I said, it's not really something you see very commonly in an academic environment because our core model is to tell people about what we're doing and let them sort of build on what we have. People are pretty familiar with copyright. It's the stuff that protects literary works, movies, books, songs, and so on. It also protects computer code. So we do tend to deal more and more with copyright in a university environment. Typically, the university tradition with copyright is that people that create stuff own their own copyright. This is not necessarily true depending on how you're affiliated with the university. But generally speaking, if you're sort of university faculty, we expect people to be able to write their papers, write books, and publish them without the university getting in the middle of that relationship. So faculty will typically own their own copyright. People that work for the university might not. And copyright's valuable. I have a little blurb on the lower right there about some big judgments on copyright disputes over songs, where one artist will say that song sounds too much like my song, you're copying my song, and therefore you have to pay me for the damages I incurred because people are buying your song, not my song. Same thing with literature. You can't write a Harry Potter book without the express permission of the publisher or the owner of the copyright. Design is, again, I mentioned earlier, sometimes thought of as a little bit I don't know, like superficial or something, but it can be really, really important. It's generally the non-functional bits of a design. So it's not the way, it's not the thing that makes the engine go. It's the look, it's the shape, it's the aesthetics. but again, can be very, very important. There were some massive lawsuits between Apple and Samsung about how they laid out the icons on their phones, and court ruling saying Samsung did it confusingly similar to the way Apple did it, infringing on Apple's design patents for laying out icons, and had to pay a whole bunch of money. So they can be very important intellectual property. Often, again, not something that shows up at a university level, because we're typically looking at the very, very low end initial implementation of the technology, not sort of the packaging and the way it gets packed up. But certainly from a user experience standpoint in computer science or other similar areas, design can show up. And then the patent, which people kind of call the Cadillac of IP, and it's sort of a double-edged compliment. It's comprehensive, it's solid, it's very strong, but it's also, maybe some people consider it a little old-fashioned and expensive. So a patent is, broadly speaking, to cover an invention. So it gives a monopoly to make, use, manufacture, yada yada yada, an invention, a design, or a method. So you stop people from building your invention. I've invented a widget and I file for a patent, and I can stop anybody where I have patent protection from also building that thing, which means if I'm going to market, I can sell it for more because I don't have any competition. Protects the functionality. It lasts for 20 years. So I mentioned the circovirus vaccine that the university has patent on. That was coming up to the end of its 20-year term. There's a bunch of patents, so it gets a little bit muddier. But patents have a 20-year term. They're national instruments, so you can't get a worldwide patent on X. You need a Canadian patent, an American patent, a British patent, a French patent, a German patent, a Chinese patent. Each one of these can typically cost tens of thousands of dollars. So by the time you look at broad patent protection, it can get really expensive. It's not just the filing costs, which are, a couple of $1,000s if everything goes well, but you need a patent agent to draft the patent. It's a very specialized kind of writing, and so then you'll have to pay them as well, and it can add up very, very quickly. So I'm going to focus a little bit more on patents because that's what we deal with more than anything else. So for something to be patented, it needs to be original, new, not obvious. So it can't just be a little tweak on something that's already known. It has to be useful, it has to be the right kind of subject matter, and you have to have some idea how to, well, not just some idea how to build it, but you have to be able to explain to someone else how to build it. You don't have to have built it, but it's generally speaking a good idea and something we like to see. Because everybody that's ever tried to build anything knows that if you haven't actually built it yourself, you're going to learn a whole lot of stuff trying to put it together. So you don't need a prototype, but you need plans that are detailed enough to allow someone, in the term that's often used, is skilled in the art, to produce it. So you don't have to have a design that's detailed enough that, your grandmother can produce it. But you do need to have a design detailed enough that a trained biochemist or whatever the field is can put it together from your instructions. And there needs to be an inventive step. There needs to be some sort of creative obstacle, an obstacle that had to be overcome creatively to be a new, novel, patentable thing. So because it has to be new, there's this concept called prior art. Prior art is basically everything the world knows about your invention before you file your patent. And that can often include what you've told people about your invention before you filed your patent. So people will often hear that, you want to be careful about publishing or telling anybody or otherwise disclosing your invention before you file your patent if you want to file a patent, because if you've already told somebody about it, it may close the door or at least significantly limit your options for getting a patent on the thing you want to protect. Another area that often gets confused with patents is that they don't give you the right to do anything. The only thing they give you the right to do is stop people from building the thing you have a patent on. So patentability is not the same thing as a very close notion, which is typically called freedom to operate. So the example that I've heard that I kind of like is, you are working hard in food science and you have come up with a design and a method and a process for creating a glazed donut. And you have your glazed donut, and you have everything you need. You can instruct a skilled baker how to make this glazed donut, and you think this glazed donut is going to be a huge hit, so you file a patent on glazed donut, notwithstanding the fact that glazed donuts obviously exist already. But you file your patent, and in the world we're talking about, they don't exist, and you get this patent granted, and you have your glazed donut, and you set up your factory, and you're going to start making glazed donuts and selling millions of these things. You're going to be Krispy Kreme. And then you get a letter from the owner of the patent of the donut saying, you need my permission because I can deny you from making donuts, and your glazed donut is requires my intellectual property to build it. So just because you have a patent, you can stop people from making glazed donuts, doesn't mean the guy that has a patent on the donut can't stop you from making donuts. There's also an important notion of inventors on patents. So this is something I like to highlight in academic presentations because inventors are different than authors on a paper. You have to tell, when you file a patent application, you have to tell the patenting bodies who are the inventors of the patent. And the inventor has to have made a creative contribution to the idea, or overcome an obstacle in actually building the thing that required a creative contribution. And the laws can vary a little bit from country to country, so you can be in bizarre situations where you might be an inventor on the Canadian patent and not on the US patent or something like that, but it's pretty rare. So a lot of things that are important contributions are not inventions. So working on the project under somebody else's instruction does not make you an inventor. Even if you put a tremendous amount of work into the project. So you could be working very closely with a supervisor who sort of tells you what to do every day, and you do it, and you work on this project for 3 years, and you may not be an inventor because you were sort of told what to do at every step. And conversely, your supervisor might be talking to a colleague down the hall over coffee and say, this is driving me nuts. I can't figure out how to get this protein to crystallize or what have you. And the colleague says, have you tried XYZ? And he goes away and tries it, and it works. That colleague, despite his sort of 30-second contribution to the project, could potentially be an inventor. So it's not the same thing as an author on a paper. It's certainly somebody who provides the funding for your lab or anything like that is not typically an inventor unless they're contributing creatively to the project. And it's important to get it right, because one of the ways patents get challenged is by saying there's something wrong with the filing, and one of the easiest things to say is wrong with the filing is that you don't have your inventor list correct. So it can be an expensive mistake not having inventor's name correctly. So I'll just throw this up there as kind of an example of a bunch of different kinds of intellectual property. The classic Coke bottle, the brand is a trademark. The package art is broadly covered by copyright. There's a design in the shape of the bottle. The formula inside is allegedly a trade secret. I don't know if that's actually true or if it's mostly apocryphal. And it turns out there's a patent on the bottle cap. It's expired a long time ago, but the way to get a bottle cap to sit on the top of a glass bottle is a Coke patent they had from like 1901 or something like that. So at one point in time, the bottle cap was patented. I guess it's still patented, but it's off patent now. So patents are expensive. The fees are considerable. So going back to the sort of overarching theme of, how do you commercialize research? The real question is, one of the first questions, I guess, is, does it make sense to spend the kind of money that we would have to spend to try to get a patent? And are we going to make it back? Are we going to make back the money from a business point of view we spend protecting something over the time that we can charge a higher margin because we have a monopoly on being able to build this stuff? Patent costs don't even get into the cost of enforcement. So your patent is only really as good as your ability to enforce it. So as I said, there's all sorts of court challenges that happen around the world in lots of different jurisdictions where company A and company B are accusing each other of infringing on their patents or intellectual property. Big companies, small companies, lots of companies. Enforcement can be as expensive or more expensive than actually getting the patent, and it can be difficult in general, especially for smaller companies. You know, in order to protect or enforce patent rights in, you know, Germany, you need to have some kind of visibility and some kind of representation in Germany, and that can be difficult for a small Canadian company. So it's another sort of thing to think of when bringing things to market. Like you may be tempted to say, I want to patent this thing everywhere I can, but then the patent costs add up and you may not be able to enforce your patent very effectively anyways. So it's a balancing act, really. And you don't need any kind of IP protection to have a successful business. You know, businesses manufacture furniture, and likely at least most of them don't have design patents or patents on the chair or the table or what have you that they sell. They just make a good chair or a table and they distinguish themselves from the competition that way. You know, 90%, I'm making numbers up, but a large number of businesses don't have any kind of intellectual protection at all, right? Whether it be a gas station or a restaurant or a hotel or what have you. If you get bigger, you know, Holiday Inn will have their logo trademarked and things like that. But generally speaking, there are a lot of businesses, especially smaller businesses, that have no IP protection whatsoever, and that's fine. But where IP gives you an advantage is it lets you develop a moat, as the lingo would be. It lets you keep competitors away and lets you charge higher prices for your products if you can keep those competitors out and you can distinguish yourself from the competition. So at U of S, IP, oftentimes when you're talking to people at U of S, they have a different interest in IP than a lot of what I just talked about. So first of all, there's a lot of talk about copyright plagiarism and fair use, largely around, you know, who is allowed to copy this chapter of the article and distribute it to their students and so on. So anybody who's a student will have had their sort of responsible conduct training and, you know, define what plagiarism is. You can't copy somebody else's work and submit it as your own. On the subject of sort of inventions at the university, so currently anything that is invented by an employee of the university, generally speaking, belongs to the university. There's a lot of ins and outs to that, and there's a lot of variations on that. But if the university is paying you, there's a good chance, at least, that the university has rights to any IP generated here. If you're faculty, grad student, that kind of appointment, there's an agreement in place that says, you know, the university owns the IP, but we have to look at it. We have to decide if we can commercialize it, and if we do commercialize it, we owe you payments back. And if we can't commercialize it, we have to give it back to you. If your staff of that's not sort of faculty, typically you don't have that same kind of obligation. Although if you're involved in an invention, people may choose to bring you in on sort of revenue sharing. If you're a student not being paid by the university, oftentimes, you know, if it's your idea created on your own resources, that's your idea, and you can, you know, the university doesn't get involved at all. There are advantages and disadvantages to having the university involved. If we take on IP, we pay for patent costs, so those expensive costs come out of university budget, not your own pocket, so to speak. And but having it your own free and clear of your own, of course, means that you can do whatever you want with it. You don't have to worry about another partner in the form of the university, sort of trying to reach consensus on what's going to be done with this intellectual property. Generally speaking, it's good to report it if there's any sort of lack of clarity. So if you're working at a lab, your supervisor is likely going to be making a decision to say, I think there's something here. I'm going to report it to Research Excellence and Innovation, and we'll look it over and we'll advise. Even if you're pretty sure your IP doesn't belong to the university, you can come talk to us and we can give advice. We can give, potential directions, maybe make some introductions for you. We're always willing to help out. If it's university owned, we can obviously do a lot more. We have a budget to do things like patenting and so on. But anybody that's got sort of research that they're looking to take through a commercial route, come talk to us and we can at least give advice. It's important to be aware as students. Oftentimes, IP on a project you're working on might be, especially if you're working on a project that's sponsored by a company, by somebody external, there might be an agreement in place on that project to assign intellectual property to the sponsor. This is increasingly common that if company X comes to the university and says, we're having a problem with something, we need you guys to work on a better way of doing what we do, and we're going to sponsor that. We're going to let you pay for some grad students. We're going to let you do some work. We're going to let you buy some reagents and consumables and equipment. But in exchange, we need to own whatever you invent coming out of that, because it's we're paying the bills, so to speak, or paying a portion of the bills. So oftentimes IP can be pre-assigned. So if you have any concerns about that, you can talk to the supervisor. They should be aware of whether there's any sponsored research agreement covering the research that's going on in their labs. And then I mentioned patents need to be new, and prior art is often yours. So presentations, publications, and other disclosure can get in the way of what you can protect down the road. So it's something to be aware of. So patents have to be novel. The most commonly cited prior art so I didn't go into the process. The process of patenting is that you apply, you send it to a examiner who looks it over, and they say, I can't give you a patent because it's not new, it's not novel, it's not interesting. They're kind of brutal sometimes. But it's their job is to try to not allow everything to get through the patenting stage, only things that are sort of valid and should be given this kind of protection. So they'll go through prior art, and they will look through everything you published, and they will look through everything you've given as a talk in principle, and it doesn't have to be publication in a formal journal. It can be abstracts, it can be a thesis that shows up in the library, that's public. Talks, casual conversations, potentially graduate student poster presentations, undergraduate research presentations. All of these things can potentially be disclosures, and a lot of times they won't be found out until somebody decides it's valuable enough to dig into it, and then that thing you thought was protecting your business might not be protecting it anymore. So it can be very important to control what you disclose if you're planning on going through a intellectual property, or if you think there's a possibility of going through an intellectual property protection route, and knowing what's been disclosed, so you can tell the patent agent what's out there, and that will allow them to sort of compensate for that in the drafting and the timing of the application and things like that. I forgot to take out the last non-correctly branded slide. So pretty much everything on this slide is out of date. But except for the fact that you're welcome to contact me. And you can, well, Merle can pass on my contact information. I think is probably attached to the slides, or to the bio or the information she has. If not, I can provide it. And
Absolutely, Chris, I can.
yeah, yeah, we're not Innovation Enterprise Contact anymore. We are no longer at 250 Innovation Boulevard. I'm not sure if that number works. I think that number might still work.
Usually phone numbers don't change, so that's a good thing. But yes, no, I'd be happy to provide your email address to anyone who's interested. Does anyone have any particular questions? I this would be a great time to put it up, but what I'm going to do is that I'm going to stop the recording and we'll do the questions afterward. But Chris, that was an absolute. I was absolutely riveted by that presentation. I learned so much, and I usually sit on the copyright side because I'm an author, so
Right.
yeah, that's where I sit. But it was really fascinating to walk through the rest of it. So I'm going to stop the recording and then we'll open it up for some questions. Thank you, Chris, for being with us today.
Yeah, you're welcome.